Hi, everyone. Thank you so much for coming to this panel. I'm really excited. We've got a great group of folks here. I'm going to let them introduce themselves, but we have four mediators from across the state of Michigan. This panel is focused on family law, but I think that anyone who's in the mediation field is going to learn a lot from our great panelists. Elizabeth Kitchen-Troop, I'll let you kick us off.
Sure, thanks. Welcome, everyone. Thanks for being here. I think this is an exciting panel, so I'm looking forward to hearing everybody's feedback today. I'm Elizabeth Kitchen-Troop. I'm an attorney and a litigator as well. I'm with Kitchen Sharkey, my firm in Ann Arbor, Michigan. I've been mediating for about 10 to 12 years. I do both litigation and mediation, as I mentioned. I have probably about a 60-40 split relative to that, and I'm happy to be here.
Lisa, go ahead.
Hi, Lisa Taylor. I've been an attorney for a long time, but stopped going to court and started mediating full-time about 17 years ago. I was told to give my mediation philosophy, which I would say is that the parties have to live with the agreements, not me, not the attorneys. They know their needs, their wants, their family dynamics better than any of us. So they should be the ones to create the agreements. I actually experienced this sort of paradigm shift when I took my first mediation training in 1999. I was a litigator then. And I suddenly realized, hey, you know what? The parties don't need me to be their parent. They don't need me to tell them what to do and what not to do. They are quite capable of figuring out for themselves solutions that are going to work for them and their families, as long as they're given the right process, the right people to help them do that in a productive way. So that philosophy has really shaped how I've conducted my mediations ever since.
And Dave Sarnacki?
Hi everyone, I'm Dave Sarnacki. I'm a couple blocks away from Emma if she's in the office. I'm in Grand Rapids. Been an attorney since 1985, and I was trying to remember when the court rule changed. It was like 2002 maybe, to provide for mediation as part of the court rules. But whatever year that was, it was the year before when we were doing all the training to get ready for it. So I've been doing it that long. In terms of a philosophy, I try to distinguish between early stage and late stage. There's pre-filing or soon, where there's no motion pending necessarily, no hearing the next day, and people have time to talk. And then I've done mediations as late as the day before trial. So I'm going to be more, because the attorneys will want that, usually more on the evaluative side as we get 2 weeks before trial. I tend to think about where someone's risk and uncertainty lies. Every attorney comes in thinking, I got the greatest case. Here's my message. Of course, you're going to agree with everything. The judge will rule in my favor in 1 hour. And, it's good to break it down and to think about all the things that could go wrong. I don't necessarily talk with them about all of that, but I like to be thinking they're going to try to give me points to take in the other room. Let's just kind of make sure that there's some reality behind how this might play out. So that's why I focus on the risk and the uncertainty.
And Matt, last but not least.
Okay. Matt Kudliska. My office is in Bloomfield Hills. I've been a mediator for almost 20 years now. As far as litigation, I've maintained a mediation and litigation practice, but I stopped taking new litigation cases about 9 months ago. I have 2 that still won't die, but I'll be a full-time mediator, I hope, sometime in the next couple of months. As far as mediation philosophy, I'm not sure quite how to answer that, other than to say that for me, a core value as a mediator is adaptability. With every mediation, we have the privilege of meeting with new people with new challenges, and all of them have different personalities, and you have to adapt to each situation. If you're just going to give the same shtick and try to apply the same formula to every case, I think you're going to settle a lot less cases. So yeah, that would be it. Thank you.
Awesome, thank you. And I think we touched a little bit on this, but I'll start with Lisa. When should people really be thinking about mediation in their case?
Well, if I can go into sort of what I do. So most of my cases are pre-filed cases or very early stage. And so I think, I don't know, am I jumping the gun to talk about the pros and the cons? I had that.
Oh, no, go right
Okay.
ahead.
Okay, so obviously, I think mostly there's pros and there's lots of pros to pre-filing mediation and early mediation. And I guess I'll start out by telling you that in the 17 years I've been doing this, I've had almost no clients return to me post-judgment. And that's because with the process that I have where we're mediating the whole case instead of litigating it.
Lisa Taylor.
I'm sorry. I just heard someone say my name.
If everyone could try to mute themselves, if that would be helpful.
Okay, sorry about that. So anyway, so I've had very few people come back post-judgment, and that's because they have, with this process of mediating the whole case instead of litigating it, that they have carefully crafted agreements with details very specific to their situation that truly help them work things out going into the future when they have problems. So you know, co-parenting issues, we've talked about that and they've figured that out, either put it in their agreement or at least talked about it. So they know that when those come up in the future, they know how to handle it. Or even if they don't have children or for other ongoing issues like spousal support, they've worked out details about how they're going to work through those kinds of things. So it's really, early mediation, pre-filed mediation really does have great results. And I know my clients are satisfied with the process and actually feel good about it because there's laughter in my room. There's a lot of smiles in my room. And I think you'll agree that in the litigation process, that's not quite often that happens, that you get much laughter in there. So the mindset of early mediation is, as I said, you're going to mediate the whole case instead of litigating it. So it's a process, not an event. Mediation is not just a one and done. So the way that I do it is it's 2-hour-long sessions, multiple 2-hour-long sessions. That's because I was trained on when I first started and have learned over the years, 2 hours is the perfect amount of time to get a lot done without being overwhelming. You know, most people just can't even think about this stuff after 2 hours. So, but during those sessions, we can really address all issues in a really collaborative way. And we talk about the information exchange, co-parenting issues, financial issues, taxes, retirement, everything. And we can even handle issues that are happening while we're working together, right? Like if they're still sharing a house, some issues that come up because of that, co-parenting issues, financial issues, all those things that would be motions brought in court. And instead, we can have discussions and talk them through and figure out solutions that are really going to work for them. And by starting these conversations early, you get people talking before their positions harden, before they get their, they really can get their interests and needs met instead of getting entrenched in these positions, right? Like I must have 60% parenting time or 80% parenting time or 50% parenting time. Well, let's talk about why. What are they worried about? What needs need to be met? And then we can figure out often very creative solutions that come up that maybe isn't 80% or 50%, but still meets everybody's needs. So obviously with the limited time and everybody else here has great insights, I want them to obviously be able to impart. But in my opinion, overall, the pros of having early mediation, pre-file mediation is that it is more effective, more efficient, and much more satisfying for all the people involved, including the attorneys, than the traditional litigation process.
Lisa, and what do you see in terms of the role of attorneys or mental health professionals or financial experts? How do you see them playing a role in that pre-filing mediation?
Yeah, well, actually, that kind of can go to what some people might perceive as the cons, right? Like that you don't have the court there to issue orders, or you might not have the attorneys there really fighting for you. But the truth is, whether it's pre-filing or early, you can have whatever you need to make sure the parties know what they're doing. So attorneys for sure, financial advisors, divorce coaches sometimes. So I always do the pre-screening, domestic violence screening, which by the way, I'm going to take a second to talk about that. So everybody I hope knows that mediators are required to do the domestic violence screening before they do a mediation. I always do that not the same day as our first mediation session, way before that. Because first of all, I want to make sure mediation is appropriate for the case. I mean, if you're already meeting for mediation and then you decide, oh, whoops, I guess this wasn't appropriate, and people are already there, that's too late. But the other reason is it really helps me to bond with the parties as well as to learn about their case. So first of all, it's to make sure mediation is appropriate, right? As I just said. But a lot of times it's just to help me design the mediation in a way that's going to make it effective for them. So first of all, I might say, I'm not taking this case unless they both have attorneys, or I'm not taking this case unless we have some financial advisors, either for one or both of them, depending on what their needs are. Or maybe I'll mediate with a divorce coach. Sometimes I do that when I know emotions are particularly high. So the long and short of it is that you really just have to make sure that you have whatever the parties need so that they know what they're doing. I mean, that's the most important thing. And I don't have any rigid formula about when I use them or don't use them. Sort of like what Matt said, you have to take each party, each case as it comes and deal with each person as, giving them whatever they need to make it the best process possible. And just one more thing about the domestic violence screening besides, for domestic violence. And by the way, when you're telling them you're doing the screening, don't say it's for domestic violence, right? Because if there is domestic violence, then the other person, the person who's the abuser, they're going to be like, oh, you're screening for that. What did you say? What did you tell her? Right? So I just say, hey, I just need to talk to you to, find out more about your personal issues, how you communicate, what your dynamics are, so I can design the mediation in a way that's going to make it the most effective for you. And what I find is then they do bond with me because I have this sometimes hour-long conversation with each of them separately. And so then when we get to that first mediation session, they feel like they know me and they trust me. And so I think that for so many reasons, it's really an important thing to do before you even start your first mediation session.
Thank you, Lisa. Matt, can you talk a little bit about, say if the pre-filing or a more collaborative approach isn't going to work, these parties are really contentious, as a case unfolds, what does mediation look like then when they maybe come to you?
Well, I mean, I would agree with about everything that Amy said.
Lisa.
I'm sorry, Lisa. I would say my perspective is slightly different from that. We sometimes talk about the legal divorce versus the emotional divorce. And I mean, love is an emotion. Sometimes you have a party who doesn't want to be divorced and would like to stay in the marriage. Hatred is also an emotion, and that has to be dealt with. And I think there needs to be a rough alignment between the legal divorce and the emotional divorce. But I mean, I'm all in favor of early stage mediation. But 99% of my cases involve attorneys who are represented by parties, represented by attorneys, I mean. And so they probably already filed in most cases, and usually are pretty far down the path. So when we discuss early stage mediation once litigation has started, it is helpful if the case is, what I call ripe for mediation. I mean, the parties have to be ready to say, okay, I'm willing to be reasonable, and they expect their spouse to be reasonable, and that sort of sets the stage for a settlement. Excuse me. Did that answer your question?
Yeah. Do you see any pros or cons in terms of waiting to mediate or?
No. No, I think if the parties are, if the case is ripe for mediation, in my view, the earlier the better. If we can skip 9 months or a year of litigation costs, then that's what that's what should be done. It used to be that parties, in many cases, or attorneys felt that they couldn't mediate the case until they had their subpoenas back, until they had their interrogatories answered satisfactorily. But with the Domestic Relations Verified Financial Information Form, we get that out there pretty early. So I would say if the appropriate disclosures have been made, I'm all in favor of mediating earlier in the process.
Thanks. Liz and Dave, as litigators and mediators, kind of looking at it from the other perspective, how do you as an attorney get your clients ready to go to mediation?
Sure, I'll get started. I do want to just kind of piggyback on something that both Lisa and Matt raised. This idea of ripeness, I think, is really important. So, in terms of sort of that pre-filing or post-filing, like when is the right time? It is certainly case specific. So, sometimes parties, there's just too much emotionality to get started with a mediation and be successful. I think the vast majority of cases can settle at mediation, and statistics bear that out. In my opinion, when a case doesn't settle at a mediation, whether I'm the attorney for the litigant or I'm the mediator for the case, it is most often, in my experience, because it wasn't ripe. The parties were still too enmeshed in the conflict. There were still too many hurt feelings. Maybe there wasn't enough data to make appropriate decisions. Maybe they needed to feel some of the, unfortunately, pain and expense of litigation in order to actually encourage them to come to the table and make some decisions. But that ripeness component, I think, is super pivotal in determining when mediation is going to be most successful. Oftentimes, as an attorney, litigator attorney, you can sort of get a feel for that based on your meetings with your client, et cetera. But not always. Sometimes that doesn't come out until you're in those first sessions and you're seeing there's an awful lot of sort of emotional turmoil that's underlying that is sort of an impediment to being successful. And sometimes that means you're waiting and coming back to the same mediator. Sometimes you're sort of shifting gears. But other than that, I will say as a generality, I do think pre-filing mediation is great. To Matt's point, those verified financials make it super useful, and those can be exchanged before the case is filed too. That happens pretty routinely. So in terms of preparing clients to attend mediation, I mean, first and foremost, just kind of setting the table for the client in terms of what to expect. What are the rules regarding mediation? What's it going to look like? Every mediation is different. Sometimes the mediator is going to set it up like a conference style. Everybody's in the same room. Other times you're going to do more shuttle diplomacy. I would say in cases where I'm involved as an attorney and it's already the case has been filed, most often it is sort of this shuttle diplomacy, mediator moving between the rooms that's happening. Not always the case. Sometimes there's a shift back and forth, but that's, I would say, more common. And then you're sort of figuring out what information do we need? Do we have all the details we need in order to make decisions? Do we need to do an exchange of information to get additional details? Do we need to do things like appraisals for businesses or residences, things of that nature in order to make decisions? You're talking with the client about, are there any time sensitive issues? Is somebody planning to move out of the house? Do they want to move out of the house? If that's an issue up front, then of course your time issue is you need to start talking about things like status quo and financial issues as well as parenting time schedules, things like that. So you're kind of figuring out in almost a triage sense what has to be addressed first and then kind of going from there. And then I think just as a generality, talking with the client so they understand effectively the legal lay of the land, sort of what they're entitled to, strengths and weaknesses in their case. The backdrop for me when I'm talking with clients is really what I think the court is likely to do on specific issues that are of importance to the client. So having some discussions around that as well in order to set expectations for the mediation. And then lastly, I'll say, sort of talking about setting expectations for what the mediation is going to look like in terms of how many mediation sessions. It is a rare case, in my opinion, that goes in and settles in one session. It happens sometimes. It is, I would say, more unusual. I think most often you're talking about at least a couple of sessions. And letting the client know that that's not atypical is helpful, I think, so that they don't go in and feel like they failed in some manner or fashion if they've gone to a session and they didn't tie up everything.
Thank you. Dave, we haven't heard from you yet. What are your thoughts in terms of getting clients ready for mediation or filing and what that timeline or mediation and what that timeline looks like?
So just a quick thing about being the mediator. I always try to start with an attorney meeting, and I tell people ahead of time, I'll do that. How can we be helpful to this family today? And that will probably tell you if people are prepared or not prepared. If they're waiting on some information, sometimes the other person can get it while you're in the other room. So I find that very helpful. I also feel that good attorneys will do that kind of on their own. They will reach out to the other attorney and say, hey, Are we still going to go ahead with this next week? We didn't get the appraisals back. Or are we going to just cover the temporary order? Or my client's not ready to make decisions on the final part, so let's focus on the temporary part. So those communications are always good. In terms of clients, clients always want to know, what's going to happen? What do I have to do? How is it going to end? And every mediation is completely different. So we never really know. But I try to focus the client on, first of all, problem solving. What are the major things that we need to get done sooner as opposed to later? Do we need to get the house listed for sale, for example? Or are there holidays that are coming up? Is the summer schedule a major problem right now? So focus on the problem solving. I try to keep the clients in a mindset of being creative and flexible. We usually will go through some kind of calculations or worksheets, but there's usually in a divorce lots of different trade-offs. You got a fruit basket and someone's allergic to pineapple. Fine, you have all the pineapple. Give me more of the strawberries. I'll take half of the blueberries. And, so usually there's a lot to trade off. And then the idea of closing a good deal. If you're looking for the perfect deal, you may be mediating for years because it's hard to get people to that point. But at some point, there's kind of the cost benefit that this is workable and it's the bird in the hand, and we can move forward into our future with this agreement. And that's usually a good deal, even if it's not perfect or what the client exactly wanted from, before the mediation started.
Thank you. Matt and Lisa, yeah, in terms of managing expectations for clients as a mediator, do you feel like you have any role in that? Go ahead, Lisa.
Yeah, well, so first I just wanted to address the ripeness for mediation issue. And I understand that. I feel like, though, that I think the court rules actually went into effect in 2000. So for 25 years, I feel like somehow it's gotten to where like attorneys barely are talking settlement until they're ordered to late stage mediation. And the traditional litigation model has become, you don't have mediation until you're ordered to late stage mediation after like the settlement conference, the pretrial conference. So that's like 4 to 6 months into the case. And a lot of times it's because attorneys are worried that there's going to be too much emotion. Clients aren't ready for mediation. So first of all, the mediation that I'm talking about, the kind of mediation I'm talking about, you do need a mediator who is very comfortable with emotion, who, if you want to do this kind of work that I'm talking about, where you're really mediating a whole case from beginning to end, you better take a lot of training in the facilitative method, in high conflict and in emotion. So you do need a mediator who can handle that. But what I have found is, if you take it in those small bites, that, yeah, you might not at the first mediation session, it might be a lot of emotion. And the mediator's job is to calm everyone down, but let them vent in a productive way. See if you can help them move forward with that and not be afraid of the emotion. So I guess I probably have a little bit of a disagreement that you have to wait until the parties are emotionally ready. Now, one thing, they have to be willing to try to be reasonable, right? To do the best they can. Okay, I'm going to try my best to be reasonable. They have to understand that something like 97% of divorces settle. You can tell them that. Look, the chance you're going to go in front of a judge is really small. Most likely we're going to settle this case. So why not start out in settlement discussions? That's a way you can get the clients sort of in the mindset of this. And you got to try your best to be reasonable. Now, if you think they're really, there's reasons why they can't be reasonable, and it's just not going to work, that's a different thing. But I have found that most people, I've mediated pre-filed cases where somebody cheated on the other person, right? There's a lot of emotion there, but we were able to work our way through it very carefully, very slowly, and maybe having a divorce coach helping with those kinds of emotions and those kinds of things. So I guess, one of the main reasons I did this, I think I said this already, but wanted to do this panel is because I want to get to young lawyers in particular, and even older lawyers, to try to encourage you to try a different way. like, try communication early and often. Bring a mediator on board early. Why not? You don't necessarily even have to use them that often, but have somebody on board. Maybe the mediator will meet with just the parties for co-parenting issues or things like that, or working out stuff that they're arguing about in the house, whatever it is. Or maybe you'll have a session where you'll all meet together just to lay the groundwork for what additional information has to be exchanged, for, discussing how the case is going to progress, what they want it to look like. You really can have, it's sort of like a collaborative case with, instead of the big C, the collaborative law process. It's very similar. It's like a small c where we're collaborating and working together, but in a much more sort of malleable process that can work for everybody. So I think that you can do this. I mean, I've been doing it for 17 years and it really can work. And I would really encourage attorneys to be more open to the idea of mediating the whole case instead of litigating it with or without a mediator. The idea of keep communications open, keep the parties involved, make sure you're hearing them about what their needs are, what their wants are. And it can really, I think, change the way family law cases are handled into something that, in my opinion, is going to be much more productive and effective for everybody.
Thank you. Matt, do you see anything as a mediator that where you step in and feel like you need to manage client expectations, or what do you do in kind of those high conflict situations as a mediator?
I mean, certainly, but I mean, I would very much encourage attorneys to have a face-to-face meeting with their client prior to mediation. In many mediations, I don't know if I'd say most, but in many, when I go into the party's room, the attorney will be handing the client the mediation summary. In other words, I haven't read about it before. If I don't ask them this, but if I did ask them this, what is your concession strategy? They would probably look at me as if I was speaking Martian. But that face-to-face meeting has to occur. Attorneys meet with clients face-to-face for hours before a deposition. Before trial, probably many hours are spent. But even though mediation is really where the work gets done in this case and probably where the case is going to be resolved, I don't see attorneys spending that productive time with their clients. As mediators, we can all recognize situations where we are centimeters from a conclusion, a mediated settlement. Everybody appears to be happy, and then one party simply shuts down. And there's science behind this. There's the concept called status quo bias. And of course, the flip side of that is regret aversion bias. These are kind of two sides of the same coin. But people tend to prefer to stay sometimes in a bad situation rather than make a change that is objectively better for them. Regret aversion bias is simply that. People are fearful that whatever decision they make, they're going to regret in the days and years and months to come. But it's impossible to deal with when it comes up at that time. I mean, once that person says, I gotta think about this, I want to sleep upon this, I want to see it all in writing, it's too late to deal with it at that point. I think the attorneys should be talking with their clients before the mediation. I think mediators in their first session with each client should start talking about BATNAs and WATNAs, which is mediator speak for best case scenario if the case goes to trial, and worst case scenario if the case goes to trial. You try to get that out early, but again, I can't stress enough the importance of preparing your client. If you're an attorney representing a party, preparing your client for trial.
Mediation.
Liz, are there things that attorneys should be on the lookout for in terms of cautious or avoid, or things where you see that just, they do it and it just shuts down the mediation?
Yeah, I mean, I think as the attorney for the litigant, you have to have a good handle on sort of how your client manages stressors and try to understand, like, Are they apt to kind of immediately go in defensive mode? Are they going to shut down? What does it look like when they shut down? So how will you as the attorney know that they've moved into shutdown mode? Can you help get them out of that? Do you need to take a break? Like, what does this look like? So I think having those advanced meetings with your clients, ideally in-person ones, so that you are getting to know them better and figure out their trigger points and how they manage these stressors is pretty important because um, you know, the worst scenario is being in a mediation and having that exact situation that Matt described, right? You're 99% of the way there, and all of a sudden some brand new issue comes out or the person is starting to shut down. So again, trying to understand how your client manages that and structure it in a way, and maybe it's those 2-hour sessions like Lisa mentioned at the outset, right? Doing it in small bites for a particular client because that's going to be the sort of maximum amount that they can sustain, and targeting, having an agenda ahead of time and targeting only certain issues that have been discussed and agreed upon in advance, that type of thing. So I think just knowing your client well enough to be aware of those types of issues that come up.
Thank you. Switching gears a little bit, in terms of marketing and business development and how you kind of all marketed yourselves as mediators, I think that might be helpful for everyone here to hear about. Dave, we'll start with you. How do you market yourself as a mediator?
I think everyone has their own style and preferences and how they do things. For me, some of the first things were to offer to colleagues, if they're handling a pro bono case, consider me, and I will not charge either for the case or maybe not charge that client. Let legal aid know, your friends at legal aid, that you're available to do that. Usually there's the court list. I tried that. I wasn't satisfied because there was a lot of administrative work involved that people ended up not having the money to deposit in advance of mediation. And just a footnote, Thunberg's rule is get the money up front. You are doing a favor to yourself, but you're also doing it to the other attorneys. I don't want mediators calling me, hey, your client didn't pay, So if you get a fair deposit up front, then you will be paid. You don't have to bother the other attorneys and things like that. But there's community dispute resolution centers everywhere, and I did those. And so that's a good source. And then, for your local bar, writing and speaking, we're doing this today, which I don't know that any of us decided, well, I need to market myself today, but it is part of marketing, is doing something to put yourself out there. The other key is to be helpful in the mediations you have. There's an attorney from the east side of the state that says, oh, Dave, he settles all my cases. So he will use me on Zoom, and we do Zoom mediations or we do in person. Some people like to have the accessibility of Zoom because they're going to be in Florida or Arizona for a month. So those are some of the things that I think about.
Any other panelists want to weigh in on how they started to market themselves, maybe especially early on?
Well, I mean, when I started out as a mediator 20 years ago, I mean, learning about how to market myself as a mediator was kind of like learning about sex. There was a lot of fumbling around and whatnot. But I think that, what I would say now in retrospect, get involved in state and local bar activities. I mean, if your desire is to market yourself to attorneys who have clients, then go where lawyers go. I think mediators typically have frequent flyers, people that regularly come to them. And I would say cultivate those, because every time one of your frequent flyers brings a mediation in, they're also introducing you to perhaps an attorney that you've never worked with before, who you're now familiar with and may use you. So I would say shower them with gifts or anything, but you know, contact and make yourself make sure your frequent flyers know that you appreciate them. I would say as well, there are parts of the state that are mediation deserts. I would say in Oakland County, there are probably 25 trained mediators for every one in neighboring Wayne County. And I'm not sure why that is, but if you have any flexibility as to where you're going to locate your office or where your target market is going to be, would be to find those mediation deserts. It's very, very difficult for a new mediator to get a foothold in a county like Oakland, for example.
Because I knew right from the beginning that I wanted to mediate the whole case and not litigate it and, you know, do this pre-filing early mediation. I marketed myself actually to therapists because I figured, you know, if they were working with couples and trying to help them communicate better and that wasn't, they still were going to get a divorce. Hey, let's keep that going in the divorce process by mediating your divorce in an amicable, communicative way as well. So that helped me a lot. I also actually talked to a lot of non-family law attorneys because I figured family law attorneys were going to look at me as their competition. So they might not, since I want to mediate the whole case, not litigate it, even though I would have attorneys, you know, represent the parties when necessary, but still I'm doing it in a very different way. And so I felt like some family law attorneys might look at me as their competition. So I reached out to other attorneys that I knew and just let them know that I was doing this. Because, you know, other attorneys have clients or colleagues or friends that they know are getting a divorce. And so if, you know, make yourself known to them, then, I mean, that works for attorneys as well. Like family law mediators can market themselves to other attorneys. So anyway, that's how I did it when I started out.
Liz and Dave specifically, do you feel like having the litigation and the mediation practices, do you think that helps you? Do you market that to clients? How do you find that working into your practice?
I find clients will comment on that. I picked you. I got 3 names, but I picked you because I saw you do mediation and they think it's better for problem solving. There's the flip side. There's going to be someone who says my spouse is going to be totally unreasonable and I need a shark. I need a, you know, so you know, if you promote yourself as a mediator, you may get some and also lose some. But I find that you know, the skills are transferable. A lot of the litigation skills that you develop put you in the mindset of what could happen if this goes to trial. And when you have the mediation skills, you could use those for cross-examination and things like that. So I see them as transferable back and forth. I also am able to see my colleagues with their clients. And it's incredibly insightful sometimes to see how people are prepared or not, how they communicate with clients, whether they are being problem solvers or bullies. But you also get a chance to work with some really great attorneys and you hear them talk to their client in a way that you say, dang, I should be doing that. That's really smart. And so, you know, I like to be able to pick up pieces along the way and use them myself and tailor them for the things that I'm going to do.
Yeah, and I'll just follow up with Dave. I agree really with everything you shared. I think for lots of clients, they see it as a benefit that you have that experience as a mediator and also as a litigator. But there are going to be some clients who are going to have this sort of flip assessment, which is, well, if you are a mediator, you're a problem solver, does that mean that you're unlikely to be as aggressive, for example? I think from my view, it is very advantageous. Like Dave said, I think it's really helpful to be able to see how other attorneys engage with their clients when you're the mediator, both so you sort of understand that attorney when you have them on the other side of cases, and also just we're always a work in progress. There's always different techniques that we can utilize in our practice that are effective or can be effective with clients, and I love that part of it. I also think this is sort of a muscle you're training, right? So as a mediator, although you care about the case settling, you're not incentivized to care about a particular client's outcome necessarily, right? And so you are looking at really the strengths and weaknesses across the board of these arguments and sort of assessing that against how you think the court might handle certain issues. I think training your brain to really look at it objectively and seeing the strengths and weaknesses in every one of the arguments, that very much translates into your work as a litigator too, and helps inform, sort of your assessment for your clients in a way that's helpful in setting expectations, and also, I think, just gives a very balanced approach to your practice. So I find it to be a very big strength. I think most of my clients do as well, but certainly the things Dave raised are accurate.
Do you feel like, and I'll open this question to anyone, do you feel like there needs to be a certain amount of time where attorneys, especially maybe young attorneys, are litigators, so they have that sense of what the court might do before they're effective mediators?
I mean, to be honest, I do a little bit, because a lot of times you have to say, as a mediator, you have to help them, if they're, especially if they're saying, well, I have two attorneys and a mediator. Oh, this is costing too much. Why don't we just go to court? It helps to be able to tell them, well, here's what court really looks like, and here's what can happen. And if you haven't really lived it, you can say it, but you won't really be able to impart to them the gravitas of what really the litigation process really will look like, and how harrowing it can be, and how you just don't know what a judge will do. And it's so much better to have the control in your hands to make the decisions here in mediation. To me, that's my biggest selling point for mediation, is it gives the power and control to the parties to really create their own solutions that are going to work for their family, rather than just, tossing up a coin and hoping that it flips your way when you go to court. So, you can, like I said, you can say that, but if you don't have litigation experience, I don't know that it's going to be quite as believable.
I mean, I don't think it's impossible. I mean, if somebody were to read the bench books and go to the Family Law Institute seminar and other great seminars that are held around the state, every case is almost like a class, and everything that happens in a case is a test, and your trial is your final exam. And you really need to learn your way around family law, if you're going to maintain an active litigation practice. So I mean, I certainly think that's the best way to learn it. On the flip side, though, I think it's absolutely necessary. And there would be a lot of mediators that would say that mediation is mediation, and you don't really need expertise in a particular area. But I don't believe that at all. I think the world's greatest labor mediator, I don't mean to pick on labor mediators, but the world's greatest labor mediator is not equipped to handle a family law case, in my opinion.
There is a difference between the simple divorces and the complex ones when you get into stock options and restricted shares and pensions and things like that. But for litigation, if you've never done it, you didn't go to motion day on Zoom and sit in front of a blank screen for 3 hours. Now, every judge does it differently, but that has been my experience with one judge. You haven't shown up for trial and found out that the judge was sick, the other attorney was sick. The trial from the day before didn't finish, and your trial will now start at 11 a.m. and 6 of your witnesses will have to find something to do for 3 hours. You haven't had clients crying in your office. Everyone probably has tissue in every room of their office, but you haven't had clients who are angry about lots of different things. So when you have those experiences, hopefully you develop the skills to deal with all kinds of different situations, to see the warning signs, to try to get ahead of things before they happen. But you can do I could walk in today and do a direct examination if I had one sheet of paper with the core facts. It wouldn't be the best direct examination, but like what happened next? So, you can do those kinds of things, but to kind of see what's happening in the mind of the client, you never really know, but the more you do it, the more likely you've had an experience that helps you understand a little bit about what they're doing. Some people will tell you, I don't want to do that, I don't want to do that. Well, what do you want to do? And you will hear people say things that are like, I don't want the divorce, or I just want to know I'll have health insurance, or so you pick those things up as you go, and it's being sensitive to the human experience that you've seen play out hundreds and hundreds of times.
In terms of kind of, getting to the level where you are ready to be a mediator, are there trainings or shadowing or activity that you all found really helpful or useful?
I'll say, oh, I'm sorry, Lisa, go
Oh,
ahead.
go ahead.
I shadowed mediators that I thought were very effective. So for folks that I worked with where they mediated cases and I liked their style, certain techniques that they used, I asked to shadow those folks when I was early in practice, and I've never had an experience where an attorney said no to that. I found that to be super useful. Other than that, I think Dave mentioned this early on too, taking opportunities to do pro bono mediations, do mediations for like the Dispute Resolution Center, or perhaps doing a mediation at a lower rate, almost like a modest means concept, doing it at a reduced rate due to the income set for the parties, just to get the experience. That alone was very helpful. Like the more you can do, the more you can hone in on your skills and figure out the areas where you can grow and improve.
Yeah, that's really what I was going to say. I did the community dispute resolution centers. That's a really great way. It's good too that you're offering your services to that, because they do great work. But you really learn a lot. And I know a couple of them do co-mediations, like that's their style, which is it's a little bit weird because you're going to be maybe partnered with somebody you don't even know, and sometimes it can be a little disconcerting. But it really is a great way to gain experience. As well as, like Elizabeth said, shadowing people and watching how they do it. That's what I did, and both things. And of course, to definitely take the training, take the 40-hour training. Don't just try to go out there and do it just from, I don't think you can do it just from reading, because the training, especially a good trainer, they do role plays. It really helps you learn how to do this in a good way, and then of course put that into use by volunteering.
Mediators might get mad at me for saying this, but as a litigator, I would try to pick different mediators for each case. And I certainly tried to pair the mediator with the case. I think that's something we haven't talked about much, but I think there are certain mediators that are more effective under a certain set of circumstances, and other mediators that might be better for another case. But I really did try to use a lot of different mediators so I could observe their style, pick up what I thought worked for me, discard maybe that I thought didn't work as well. I thought that was a good way to learn, because to become a mediator, you have to do some shadowing, but I don't think that's really enough experience. I think you need a lot more observation time.
There's a lot of mediation specific training, the ADR section, ICLE, there's national types. There's training for child custody matters and things like that. There's a lot of psychological aspects of it, cognitive bias, negotiation skills, communication skills. So I would encourage people to look beyond just, what mediation things are coming up. And the State Bar used to have on their website a listing of all the ADR section trainings from across the state. So I don't know if they're still doing that or if that's up to date, but it's a good way to find out about things that are coming up.
I guess I will plug also the ADR section, as Dave mentioned. Become a member of the ADR section. I think it's only $40. It's pretty inexpensive, and they do amazing trainings. And the listserv always announces, and on their website, they announce different ADR trainings. And it's not just mediation training. It is about, learning about how the brain works, how negotiation works, all sorts of things that really help you as a mediator. So that's definitely helped me as well.
Thank you. I want to make sure we leave enough time for questions. So if people have questions, feel free to put them in the chat, or if you want to use the raise hand feature on Zoom. But I know we've got 4 great panelists, and so eager to hear any questions you have for them as well. In the interim, do you all think there's a benefit in, building the relationship with the judges and getting on those court rosters? I know, Dave, you had talked about maybe some of the issues with the roster list, but
Judges are not supposed to pick mediators. I see it sometimes on motion days. They will have their, a referee or a judge will say, well, why don't you go to person A or B? Now, if they said Dave Sarnacki, I'm perfectly fine with that. That's you hear this, and it's difficult to say no. You might have a specific reason why you don't want to use that person, or that you think, like Matt said, the case might not be appropriate. The match and fit with that mediator might not be good. So I don't think it's good that. All right, sorry, I'll take a minute here. If I do a pro con and the mediator was helpful, and I've done this since, for 25 years, I always mention the mediator. We were able to resolve this case with the assistance of Matt Kobliska as our mediator, blah, blah, blah. And that way, that's a good way for judges to be remembering that mediation matters, keeps their dockets lighter to some extent, and you're doing some good work as a group.
we have a question here in terms of, and maybe there's not a difference, but clarifying the difference between shadowing versus observation, and maybe kind of what some of that training specifically looked like.
Oh, Liz, I didn't know if you want to take that.
Sure. I mean, I was really using them interchangeably, frankly. And as a part of the mediation training, I can't remember, it's been a long time at this point, but I know that there is some requirement. I want to say it was you have to do 2 observations, observe 2 different mediations. And so that's a part of the requirement, at least for the court roster, I believe. Other than that, it can look like co-mediating in some cases too, but I was speaking specifically those as sort of interchangeable terms.
Yeah, I mean, when I started and did it, I was new, so they, the mediators so I don't know, shadowing is I didn't shadow. I just sat in on their mediations basically, and so watched what they did, talked to them maybe a little bit before the mediation to ask how they got prepared, but they didn't want to, co-mediate with me at that point because I was new and, they didn't know what I would do. So, so I usually just kept my mouth shut and just watched. If there was a break and I thought of something, I might talk to the mediator and say, hey, why don't you try this? Or I noticed this or whatever. But it was really more just observing and taking in how different, and if you go to different mediators and you see different styles and you can, get, oh, I like that they did that. I don't like that they did that. So just sitting in on mediations really, I think was helpful to me.
We have another question here. Do you ever sue for your unpaid fees?
I have not, but I get deposits up front for every session, so it's usually a nominal amount that I would not have, but I learned that lesson probably 22 years ago, where the attorney was a friend of mine, but they got fired or they fired the client, and now I got a client out on an island. Well, they're unhappy, and the last thing they want to do is pay me. So that was it. Deposits up front.
I mean, the only time that I was ever like owed any money of any significance is during arbitration cases. And I know that other arbitrators and I do as well, don't release the arbitration opinion until all fees have been paid. Because there's going to be someone who's going to be unhappy, probably, with the arbitration award, and maybe two people that are unhappy with the arbitration award. But I've never had that issue with mediation. I've written off a couple $100, but that really hasn't been much of an issue.
In terms of when you actually reach an agreement, as mediators, do you usually end up recording it? Do you type it up and have the client's DocuSign right then and there? How do you approach reaching an agreement?
That one I wanna chime in real quick because I do things so differently. It's very different from what I do. So we'll meet for 2 hours. They'll reach some agreements. I'll go and draft that part of the agreement. We get back together again and I read out loud with them the draft that I created. They're still not going to sign it. That we're going to keep talking, and then maybe they'll reach some other agreements. I'll draft that, add that to the agreement. We'll get together and read the new stuff. And so by the time we get to the end, we have all gone over the agreement multiple times. They've had time to go take it and think about it, talk with their attorneys more about it, get back together, rediscuss things. So at the end of the process, which can be a couple months, when they sign the agreement, it's really their agreement, even though I sort of initially drafted it, because we all work together to fine tune it and get it exactly the way they want. And when they sign it, they know what they're doing, they feel good about it. And I think that's very different from the traditional late stage, get it done, because otherwise we're going to trial, you better sign it, kind of pressure. So my cases don't have that kind of pressure. So it's different, I think, than what the other people may experience in their mediations.
I mean, I encourage attorneys to prepare a settlement agreement or consent judgment divorce in advance of mediation. Look, they're going to have to prepare one anyway. So why not do it beforehand? And certainly the starting version of that document is not what we're going to end up with, but it's something that we can tweak. I mean, all the attorneys now show up with their laptops. We can make tweaks to it. And if we can get it in writing, particularly if it's a final consent judgment, then really nothing needs to be done at that point in time. I do audio recordings as well. Sometimes you get into judgment language issues then, but I mean, usually not. That's kind of the rare case. I don't type up anything. I'm too concerned that if I spend 15 or 20 minutes typing out a term sheet, that somebody's going to change their mind and walk out. So I never do that.
I do a fair amount of typing in mediation, so it is not infrequent for me to I put myself in attorney jail in a separate breakout room if I'm doing it via Zoom and draft up an agreement. So that happens, I would say, in a large majority of my cases, but oftentimes attorneys will come in with a draft of an agreement we can modify, or if we get to the end of the session and the attorneys feel pretty strongly that they want to get something preserved and don't want to take the time either because we've run out of time for the session or we have to conclude the session for whatever reason, then it is not infrequent. We'll do recordings as well. And one of the attorneys will sort of be tasked with coming up with the draft that comports with the recording thereafter.
Liz is a better typist than I am. Well, I used to do it that way, not that I was doing the typing, my assistant would do it, but I would come out of one room and I'd say, write up an agreement with these 5 things, and then I'd go in the other room, and then I'd say, okay, take that 4th thing out or change it. I kind of fall into the recording if we're doing Zoom now. The other thing I ask, have you prepared anything? Sometimes it's apparent to me that this agreement is going to be more important for one person or the other. And I might say, well, why don't you start sketching out an email that has the terms that you're going to want? Don't send it, just so that we can, and then they'll have it kind of ready and they'll be adding 1 or 2 items on the back end instead of starting from scratch. But then I think it was Matt, we don't have to be the author of the words. It's the attorney who's got to put the judgment together and present it the way they want it. So.
All right, well, I think we are right at our time. So thank you so much to our panelists. I know everyone really appreciates your insight. So thank you all. And hopefully for those of you who haven't, oh, go ahead, Dave.
I just saw a question about, do I record the mediation? I don't record the mediation. I would record the settlement. Yeah,
I'm just going to piggyback on that. Remember, mediations are confidential, so you
Right.
really shouldn't record them. Recording the settlement is okay, but don't record the session because it's supposed to be confidential.
Perfect. All right, well, thank you all. And hopefully you'll consider these 4 mediators for your next mediation issue. Thank you all again.
Thank you, everyone.
Thank you.
Thank you. Appreciate you, Emma, for putting this together. It was great.
Yes, thank you,
Good work, Emma.
Good work.
Thanks, guys.